On this episode of Law Weekly, we discuss labor issues, especially that of Kaduna State and the judiciary workers' strike, seeking the implementation of the financial autonomy of the judiciary. We have the views of senior legal practitioner Jiti Ogunye. Also showing on the program, the Nigeria Governors Forum shares more of their perspectives on the financial autonomy of the judiciary. The chairman of the NGF and his vice spoke in Ado-Ekiti, the Ekiti state capital, during a colloquium in honor of the retiring chief judge of the state. Plus a few interesting suggestions for constitution review from some senior lawyers. Hello and welcome to the program. I'm Shola Shuyeli. The governor of Kaduna State fired 19 political appointees in the state as part of his administration's move to right-size the public service. This follows the recent controversial layoffs in the state, which led to the now suspended industrial action by organized labor. Before the recent sack of political appointees, however, I sat down with senior legal practitioner Jiti Ogunye to look at the legality of the sack of workers in the state. Can the governor's action rightly be described as courageous? Here's Mr. Ogunye's take.
Contrary to what the law dictates, the state government came up suddenly to say that it wanted to retrench workers. And it started with the campaign that the money being used by workers from the IGR of the state and from the statutory allocation to the state government from the federal purse is just too much, and that the workers are just a little fragment of the entire population, and that therefore it will be in the interest of Kaduna State to retrench those workers. That could be an aspiration. Is it legitimate? I don't think so. Certainly not lawful, because these workers that the government, and I don't want to personalize it by saying the government of Kaduna State was saying that it was going to yank off the public service, had their employment, having statutory flavor, meaning that once they enter the public service or the civil service, they have a guaranteed service year or service tenure, and that is either they will retire when they clock 35 years in service or when they attain 60 years biological age, whichever is earlier. And so, under the public service rules and their conditions of service and all enabling laws, you just can't yank them off except they've committed offenses recognized by law and they are punished duly under the public service rules. It's not a matter of saying that, I've now realized that I'm broke as a state. I don't have money and all that. Even if that were applicable, to say that there's no money to pay and that you are declaring redundancy in the sector, where under the principle of first to come, last to go will apply, you still have to follow the due process. You still have to make a declaration to that effect. And so if there's a collective bargaining agreement or some sort of agreement, the workers will then negotiate this. But what happened was that the governor or the government woke up suddenly and said that they wanted to do this. And when the workers then kicked through a legitimate strike, in my view, as I've said, the governor embarked on saber rattling, making incendiary statements, threatening their national leader that they should not come to Kaduna State, that they will be dealt with severely if they showed up and all that. Assuming without conceding that the workers even embarked on the strike unlawfully or illegally. As a government that embodies legality, because when you're wielding an executive authority, you are an implementer of laws. You are the one to enforce the law. So will you then resort to illegality to confront the alleged illegality of the workers in embarking on the strike? No. You will declare a dispute, because either party can declare a trade dispute and then look towards the law, look to the law for redress, for adjudication of that dispute. The governor didn't do this. And I feel strongly that the governor didn't act right in that instance. I know that a lot of people have been talking about courage. Yes, the states are burdened by wages and pensions, so money needs to be freed to be deployed to capital projects and all that. There is no courage here. Courage means that you have the capacity to bear a burden that is not easy, particularly if you are put in government to bear such a burden. The government talked about providing employment, talks about creating an enabling environment for employment to be generated. So do you do that by sacking workers, thereby ruining their lives and means of livelihood, and thereby ruining their families? That's not what a government does. A government elected under the Constitution, we provide that the security and welfare of the people shall be the primary purpose of government. And I'm referring to Section 14(2)(b) of the Constitution. So I don't think that the government of Kaduna State acted fairly, legally, and lawfully in this regard. And what we've been told now is that the two parties, after that fight, are now come up. A 10-man committee has been set up. Which should have happened in the first instance.
Now, sticking with issues of strike, state governors and the leadership of the Judiciary Staff Union of Nigeria, JUSUN, and the Parliamentary Staff Association of Nigeria, PASAN, have finally entered into agreement on the modalities and timelines for the commencement of full financial autonomy, which is the root crisis of this strike. According to the Minister of Labour and Employment, Dr. Chris Ngige, the governors have studied this document and they are in agreement with it. And by Monday or Tuesday, we will see a trigger of the Section B and D, which says governments of the respective states shall credit the accounts of the legislative and judicial arms of government with a pro rata amount due to each arms of government under the 2021 appropriation law. Now, do you think that this is a solution that will work?
Let's start with what the resolution, the term of that resolution that you just read out, as stated. It states, if I heard you correctly, that the government of the respective state shall credit their accounts. That's what the Constitution provides. Section 121, subsection 3. That the amount standing to the credit of the judiciary, which shall be a charge on the Consolidated Revenue Fund of the state, because the states in the federation have their consolidated revenue funds, as well as the federal government that has its own consolidated revenue fund. So this shall be a charge on the consolidated revenue fund of the state, and this amount shall be deducted and then be given to the head of the judiciary of that state. The argument before now has been that the states were not complying with this. There's been litigation, there've been actions and all that. And in order to force the issue, let's have a general nationwide strike, shut down the courts to put pressure on the state or the federal government to do something. And people have been looking up to the federal government. Indeed, there have been a suggestion that based on Executive Order 10, that the Accountant General of the Federation should be mandated to deduct the money from the source, from the center, and then give this money directly to the state. That would be a violation of the Constitution. That would be a further drive of Nigeria on the unitary path, in which case the country will be broken into several administrative centers, fiscally speaking, that will be tied to the almighty center. So the center directly will be giving money to the parliament, it will be giving money to the judiciary, with its attendant implication for cohesion of governance within a state. In a federation, states are units. They enjoy semi-autonomy within their domain. Government is whole, although there are three arms of government. So that provision, that in that term, in the putative agreement that the Minister of Labour spoke about, is the path to tread. But that does not determine or answer all the headaches that will come along the way. We have reservations about these provisions. Yes, I want the judiciary to be independent. I want the legislature to enjoy a degree of independence, but this should be done and worked out within a state. Once this so-called vote or the amount standing to the credit of the judiciary is given to the head of the judiciary of that state, the question that follows are as follows. One, would the judiciary then be the one to drop its budget in promotion of its own newfound financial autonomy and independence? So if it draws up its budget, will it self-approve its budget? If it doesn't self-approve the budget, will it then go back to the legislature that is run away from because it wants to be autonomous and independent to then say, pass the budget? In which case, judges will now be the one to go before the legislature to be defending their budget with all the attendant implications. Number 4, judges would they now have to have a tenders board in the judiciary for contract, for capital expenditure, awarding contracts and all that. And if that were to happen, what we see in the executive, where contracts are awarded and corruption follows, or in the legislature. So would that not happen in the judiciary? If it happens in the judiciary, are we therefore near that day when judges will now be going to the EFCC every day or ICPC in respect of the contract they have awarded and in respect of alleged kickbacks? I mean, these are the issues. And right now, enough anticipatory and proactive discussion that would deepen the debate. We're not having that. And that's a problem for me. So yes, the judiciary should be independent. The judiciary should have financial autonomy and all that. But really, it is not the province of judicial officers to now be awarding contract and spending money and all that. It may create other problems that could be worse than the one we intended to solve. That's my apprehension.
Finally, the Attorney General of the Federation, Abubakar Malami, SAN, said in an interview on Wednesday that open grazing of cattle cannot be banned in Nigeria without an amendment of the Constitution. And I'm sure you heard his comments on the spare parts, the example that he gave about the spare parts. But what are your comments on those views?
I think that the Attorney General was wrong. The example that he gave was not apposite. The example that he gave was also problematic, talking about national cohesion. The truth of the matter is that most spare parts, auto spare part dealers in the north are from the southeast. Many of them, even in the southwest, are from the southeast. So when you then pick that example to suggest that they could be driven away, you are doing what some other people usually do when there is a national crisis, like saying that they are going to drive some people away from certain parts of the country and all that. And I think that the Attorney General shouldn't have done that. But more substantively, his argument is a sophistry, is specious. You don't need to amend the Constitution. Section 41 of the Constitution is plain. It guarantees right to freedom of movement. And that chapter is called Fundamental Human Rights. I think the Attorney General should be told that it's not labeled fundamental cattle rights. It's fundamental human rights. Human rights are the ones that have the power to move across borders, state boundaries and all that, all over the country. Not cattle, not animals. In any case, the land law in the country, and this is basic, this is elementary, that we all learned in the law school, recognizes the right of first settlers. So these grazers, these nomads that are coming, are trespassers. They are trespassers, except you are just going to discard the land law in Nigeria. And I'm not even talking about the Land Use Act that makes the governor of each state the trustee of the land for the benefits of Nigerians. If you go to our criminal code, given to us by our colonial masters, 1945, criminal code, penal code, there are provisions therein that obligates people who rear animals, dogs, to keep them. To keep them. Not to talk about cattle, to keep them so that they do not cause nuisance to other people. So for anybody in the 21st century now to now be so agitated that cattle rearers, nomads who are itinerant, some of them foreigners who are bringing weapons into this country, are now being allowed to destroy farms and settlements in the name of freedom of movement. The learned Attorney General of the Federation is a senior advocate of Nigeria, and there is a presumption that he's learned.
Now, away from that interview, there appears to finally be some light at the end of the tunnel, as the leadership of the Nigerian Bar Association has expressed the view that the June strike, which has entered its 8th week, may soon be called off. The president of the bar, Olumide Akpata, in a statement released last week, Saturday, May 22nd, said stakeholders have agreed on an action plan for the immediate implementation of the financial autonomy of the judiciary, particularly in the states. The chairman of the Governors Forum and his vice spoke on these issues in Ado-Ekiti at a colloquium with the theme, The Judicial Autonomy Perspective of the NGF, organized by the Ekiti State Ministry of Justice Academy in honor of the retiring Chief Judge of the state, Justice Ayodeji Daramola.
As governors, we'll be failing in our responsibility if we refuse to draw the attention of the President, stakeholders, and the country to grave concerns about the constitutionality of the Executive Order 10 of 2020. That was the basis of the position we took on the Executive Order 10. The Executive Order 10 ostensibly intended to support the implementation of judicial financial autonomy was completely unnecessary and ill-advised. Let me at this juncture state clearly that we have never questioned the right of the President to issue Executive Order 10 or executive orders at all. We only stated that Section 1213 did not require presidential executive fiat to become implementable. Provisions of the Constitution are self-executing, and Section 121(3) is not an exception. Though adequate funding of the judiciary is necessary, the presidential directive to make special extraordinary capital allocation for the judiciary is an unlawful interference in the governance of states, as allocations are made based on the needs and priorities of each state and availability of funds. The president cannot dictate to the governor or the state government what it should do within a specific time frame in their budget. While the delay in implementation of financial autonomy of the judiciary is simply a matter of procedure, governance structure, and the quest for legal clarity.
But there is still that sticky point that my brother mentioned about whose responsibility really it is to take charge of capital funding of the judiciary. As a matter of fact, you may be aware, my lord, that the Nigerian Governors Forum has a case in court on that particular issue, because the provision of the Constitution cited by His Excellency the Governor of Sokoto State is one that seems to us very clear that this is a matter for NJC to settle, but NJC has not done one thing on this since the 1999 Constitution came into operation. We've carried that burden for as much as we can, and in many cases, not well enough. So if it is something that they want states to carry, it's not a problem. At least let's be clear that this is the responsibility of the state, not the responsibility of the federal through the National Judicial Council. So for us, that aspect is one that we will still have to continue to work on. But on the one that we have agreed to do, we definitely will honor it, and we will continue to hold our judiciary in reverence, because we know that without it, this democracy cannot endure. It cannot be sustained if we subject the independence of the judiciary to the jackboot of the executive. And that is not what any of our governors really want to do. And this is something we make very clear to all of ourselves in our various meetings as governors of the 36 states.
And just before we go, let's bring you some of the submissions that some senior lawyers have made before the Southwest Constitution Review public hearing in Lagos. Besides warning that some parts of the country are experiencing what he described as civil war, Senior Advocate of Nigeria, Femi Falana, also made a case for the poor and the vulnerable.
We are submitting that the Child Rights Act, enacted beautifully by the National Assembly in 2003, be made applicable throughout Nigeria. We have to work it out. As of today, only 25 states have adopted that law. But even then, they are not being implemented. Some of the states that have refused to adopt the Child Rights Law, some of them include Borno, Katsina, and all those states where banditry and terrorism have virtually been institutionalized. So if you don't send our children to school, because we have 40 million children today, children of the poor roaming the streets, and that is where bandits, kidnappers, terrorists, and all of them recruit on a daily basis. And I think a member here trying to sponsor social security bill. I think it is high time we make the social security bill to work. People who have no jobs must be given something at the end of the month. Otherwise, they are going to make it impossible for the rich and all of us to enjoy our freedom.
Constitution must be affirmative in its aspiration. If we want Nigerian women in decision making, including political participation, the Constitution should be bold enough to assert that in very clear terms and not assume that people will pick it up. So we ask that we need a clear statement guaranteeing 30% position for women in decision making, which will be elective and appointed positions. And specifically, we call for Section 14.3 amendment. Section 14.3 has to clearly expand federal character to include gender diversity, as well as Section 14.4 and Section 14.5 should validate affirmative action to entrench the same way as is done for federal character should be done for gender diversity, youth inclusion of people with disability.
We think that what should be addressed very critically in the Constitution is the appointment procedure to the bench. The problem really is that of capacity and not, well, I would say capacity and character, and not overburdening of the courts by jurisdiction. We think that we should not begin from the end. Nigeria, as at today, with all respect, is not ripe for a reduction of the appellate jurisdiction of the Supreme Court. We should wait till a time when judicial outcomes are respected. Because I'll give an example. If decisions of high courts are respected, if decisions of high courts enjoy a lot of quality, litigants will even be discouraged from going on appeal, because they will take a judgment, they will look at the facts, they will look at the application of the law, they will know that these judgments can hardly be faulted in law and logic. Naturally, at that stage, appeals will reduce. But now that judicial outcomes are probably not respected, there is apathy, so to speak, against the judiciary. We now want to curtail the rights of citizens to appeal in very, very critical issues. The outcome with respect for us might be dangerous.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shiele. Thank you for watching and see you next week.